This is Group 2, and our topic is Intellectual Property Innovation. Group members are Juan Almanza, Juan Fuentes, Robert Jones, Stephen Montoya, and Tyler Doe.
The ownership of intellectual property inherently creates a limited monopoly in the protected property. Intellectual property is traditionally comprised of four major categories: a patent, a copyright, a trademark, and trade secrets. Innovation means making something new that is used to enhance the product, process, or service. There are so many innovations that can be protected through intellectual property rights. Intellectual property and innovation helps in gaining the rights which are required for getting your work protected from others that try to claim your work as theirs. Technology relevance to engineering. Real-time innovation. For instance, developing a new car model of a car typically took around 4 years, with the model staying on the market for 7 years. For aircraft, the combined timetable for development and the equipment's time in service can be 3 or 4 times longer than for automobiles. Given the current pace of technological change and adoption, that's too long. Technology is changing the playing field for engineers. It alters the culture by providing a more real-time data on the performance of the equipment in the field today, allowing engineers to consider improvements that can be achieved in months through data algorithms rather than years or decades. Instead of focusing only on breakthrough technologies of new models, engineers can significantly expand the capabilities of equipment already in service through the incremental upgrades in software downloads or the incorporation of new sensors. Outsourcing was once a means of cutting costs, but today it's done to across new skills in areas like reassign legacy work, so in houses engineers can focus on new technologies or artificial intelligence. That often involves collaborating with technology startups. Making sure that products keep up with the technological advancements costs large sums of money at a time when most manufacturers are forced to look for cut costs in order to improve their profit margin. Understanding the process of innovation. As shown in the figure, the processes or steps of innovation are very important in the market today, especially for business. First, you or a group of people come up with an idea and start putting in time and energy into the project and see it grow. Eventually, if enough support is done to the project, it will be accepted into the market. Ethical issues. Measuring contribution. An issue which commonly occurs is the question, how do my group members and myself get contribution measured? How is contribution scaled higher than someone else's contribution? Another ethical issue is when people start earning money for a project and the members believe they should earn more money because the contribution is better than the rest, and thus they should have a more percentage of the product or service. Another ethical issue is how the advisors and other organizations may claim to the intellectual property in the innovation that was discovered. The works, codes, schemes, or other forms may be protected under copyright law as creative works, the same as a book, a movie, or a work of art. And often to the coder, the source code is a work of art. Copyrighting your work can prove to be problematic for a variety of reasons. For a start, you may have to publish details of your work in copyright documentation, which can give competitors an edge. Therefore, software and tech companies generally use patents to protect the initial idea and trade secret law to prevent sensitive aspects of it being leaked out. Copyright laws exist to protect the expression of that idea, and trade secret legislation exists to protect a company's competitive advantage in the marketplace. Others may already have a patent pending for a similar idea as you. Therefore, if you have an idea that is new, it's crucial for people to submit a patent for review before someone else with a similar or better idea can submit theirs.
So, what is copyright? Copyright is a type of intellectual property that protects artistic expressions like music, films, plays, photos, artwork, works of architecture, and other creative works. The term creative works is defined very broadly. How long does copyright last? The duration for copyright varies according to the type of copyright work you own. For literary, dramatic, musical, and artistic works, protection lasts 70 years from the end of the year in which the creator died. Specifically for photographs, or if the work is published after the death of the author, it lasts for 70 years from the end of the year in which the work was first published. Copyright protection for published editions of literary, dramatic, musical, and artistic works lasts 25 years from the end of the year in which the edition was first published. Sound recordings as well last 70 years from the end of the year in which the sound recording is first published. Broadcast and cable programs last 50 years from the end of the year of making the broadcast or cable program. For performances, copyright protection lasts 70 years from the end of the year of the performance. When it comes to owner's rights, a work created in fixed form is automatically protected by copyright. The author immediately owns the copyright in the work and only he or she enjoys certain rights, including the right to reproduce or redistribute the work, or to transfer and license such rights to others. In the case of works made for hire, the employer and not the employee is considered to be the author. Section 101 of the copyright law defines a work made for hire as a work prepared by an employee within the scope of his or her employment. When it comes to journalists, if you created a work while employed as a journalist by a newspaper, magazine, or other periodical, and the work is created for the publication in these mediums, your employer will automatically have the right to publish and reproduce these works and publications. However, you, as the journalist, still have the right to publish the work for other purposes such as collation into a book. For collective works, or works that are comprised of several independent works, such as an encyclopedia, the authors of each independent work hold a copyright for each contribution. There can also exist distinct copyright protection for the collective work as a whole, since creativity is involved in selecting the individual works and compiling them. Before using any copyright work that belongs to a third party, you should always get copyright owner's permission. This way you can avoid the risk of copyright infringement. Infringement can occur when you have not obtained the consent of the copyright owner to do something that only the copyright owner has the right to do. For example, making a photocopy of a textbook without the consent of the publisher would lead to infringement. To obtain consent from copyright owners, you may contact the copyright owner directly and negotiate for a license to use the copyright material, or obtain a license through a collective management organization. Do not assume that whatever is posted on the internet is fair game for copying. Before you copy or use any material available on the internet, always check if the website has terms and conditions governing use of the content on the website. A link to the terms and conditions can usually be found at the foot of the home page. Copyright, like real estate, can be sold or leased. Selling your copyright means transferring or assigning your ownership of the copyright to a third party. This will lead to losing ownership of the copyright and control over permission of use for the copyright. Even with the assignment of copyright, you may still charge third parties a fee for using the copyright. While leasing your copyright means licensing a third party specific uses of the copyright protected work, which will retain your ownership of the copyright. You will also still have full control over the copyright, and third parties will have to request for use of the copyright. The assignment and licensing of the copyright can help generate revenue streams for copyright holders. The transferring and licensing of copyright is usually carried out by a written contract together with payment fees.
In this part of the presentation, I'll be talking about patents. First, we'll discuss what is a patent. Secondly, we'll go out through the history across the world of patents. And lastly, effects that patents have on um, intellectual property. A patent is a form of intellectual property that gives owners the legal right to exclude others from making, using, or selling an innovation for a limited period of years in exchange for publishing and enabling public disclosure of the invention. In most countries, patent rights fall under private law, and the patent holder must sue someone infringing the patent in order to enforce his or her rights. In some industries, patents are an essential form of competitive advantage. In others, they are irrelevant. Although there's some evidence that some forms of patent rights were recognized in ancient Greece, in the Greek city of Sybaris, the first stationary patent system in generally regarded to be the Venetian patent statute of 1474. Patents were systematically granted in Venice as of 1474, where they issued a decree by which a new inventive device had to be communicated to the Republic in order to obtain legal protection against potential infringers. The period of protection was 10 years. As Venetian immigrated, they sought of similar patent protections in their new homes. This led to diffusion of patent systems to other countries. Important developments in the patent law emerged during the 18th century through a slow process of judicial interpretation of the law. During the reign of Queen Anne, patent applications were required to supply a complete specification of the principles of operation of the new invention for public access. Legal battles around 1796, patent taken out by James Watt for his steam engine, established the principles that patents could be issued for improvement of already existing machines, and that the idea or principles without specific practical applications could also be legally patented. Influenced by philosophy of John Locke, granting of patent began to be viewed as a form of intellectual property right, rather than simply obtaining an economic privilege. Finally, the first Patent Act of the U.S. Congress was passed on April 10, 1790, titled An Act to Promote Progress of Useful Arts. The first patent under the act was granted on July 31, 1790 to Samuel Hopkins for the method of producing potassium carbonate. Revised patent laws was passed in 1793 and in 1836. A major revision to patent laws was passed. The 1836 law instituted a significantly more rigid application process, including the establishment of examination systems. Between 1790 and 1836, about 10,000 patents were granted. By the American Civil War, 80,000 patents have been granted. Alright, we'll discuss now the effects of patents. A patent does not give the right to make or use or sell an invention. Rather, a patent provides, from a legal standpoint, the right to exclude others from making, using, selling, offering for sale, or importing the patent's inventions for the term. of the patent, which is usually 20 years from the filing date. Subjects to payments and maintenance fees. From an economical, practical standpoint, however, a patent is better and perhaps more precisely regarded as a conferring upon its proprietor a right to try to exclude by asserting the patents in court. For many, granted patents turn out to be invalid once their proprietors attempt to assert them in court. A patent is limited to property right the government gives inventors in exchange of their agreement to share their detail of their inventions with the public. Like any other property right, it may be sold, licensed, mortgaged, assigned, or transferred, given away, or simply abandoned.
In the United States, design patents differ from the more popular utility patents in that they only protect the shape of the design and not its functionality. This could be useful in many different areas, such as the car industry, where you can protect the exterior design of a car, or in the fashion industry, ensuring that designers get full credit for their clothing. Design patents don't have to cover the entire design and can be used on specific parts, such as the handle of a vacuum and not the vacuum itself. Design patents can last for 15 years from the date of approval, and in general are easier to obtain and cost much less to apply for. This is because the drafting of a utility patent requires much more effort to support its functionality and describe its specifications. Utility applications have to be carefully planned, where each word has a specific purpose and the overall idea of the design must be unambiguous, or in other words, impossible to interpret in any other way. This is not the case with design patents, as they rely heavily on drawings and pictures to describe what is being examined. This also means that when submitted to the office for examination, the applications are far less likely to be rejected, and the applicant will not have to spend extra time and money to redraft the proposal, hire a professional patent examiner to find flaws, and repay for the application fee. The figures below are two examples of design patent drawings and pictures. On the left is a sample design patent of a Chevy Corvette where the shaded part is what is being examined. When looking at design patent drawings, it is important to note that any dotted line is to be ignored and is not part of the actual design patent. This means that when the final design is finished, the shaded areas of the design must remain the same in order to be protected by the patent, and the dotted lines can be completely different from what was originally submitted. On the right, you'll see an example of an infringement of a design patent where Nike's design is on the left and labeled Figure 4. On the right, you'll see an image of a Walmart shoe that clearly mimics the design patent submitted by Nike, which could leave them open to lawsuits. Criteria for approval. Restrictions and criteria change depending on the country you apply in. For example, the UK's design rights are more encompassing of what can be considered protected. These design rights are different from the United States design patents in that they not only protect the overall shape of a product, they can also cover textures, fastenings, patterns, and other surface decorations. There are two main criteria that must be met to get approval on either design rights or design patents. The first criteria is new, or is what is being examined considered new. This means the design must not have been disclosed anywhere before the filing date, or in other words, it must not have been a public knowledge idea already. The second factor that must be met, does the design have individual character? This means, does the overall impression differ from prior known designs, or is it original? If these two factors are met, then the draft can be considered unique and can move further through the application process. Design patent application. There are many different steps involved in submitting an application for a design patent, but the following 6 items could be considered the most important parts. Novelty search is a process of researching various resources to ensure that your design is original and not already patented. This can be difficult to do because the shape or form of an object is complicated to describe in words, therefore you have to go through hundreds, if not thousands of pictures and drawings to see if there's a similar design out there already. For this step, it is important to have a professional patent examiner to help in this research. The preamble is the introduction of the design, a brief description, and the inventors applying for the patent. Cross-reference is a step that states what other designs made by someone else are part of your design. For instance, compartments, fasteners, or even a type of string might be necessary to mention here. This step gives credit to the invention and the inventor that made your design possible. The claim is where you would give a full description of your design. However, as stated earlier, shapes and forms are easier to understand with pictures rather than words. A simple statement would go here instead that states, refer to the drawing for the complete description, or something along those lines. For utility patents, however, this step must be as detailed as possible in words. Messing up here is the biggest reason utility applications are rejected. Next, drawing and photos would be added here and have to be as detailed as possible with proper shading and lighting. It is important to get every angle, curve, and contour of your design in order to ensure your application is reviewed and processed as quickly as possible. The last step is to submit the application for review. In all, it can take 1 year to 2 years for the patent to be approved. This number depends on how many times you had to amend any mistakes found in the review process. Therefore, it is important to be as careful and organized as possible in the first 5 steps of this process.
So next I'd like to talk about what is a trademark. A trademark is a word, name, or symbol that a seller uses to distinguish their goods or services from other sellers. Types of trademarks include logos and brand names like you see on commercials on TV or on the street as you're driving by different restaurants and stuff. Item names like the Whopper from Burger King. And the shape of the item. The shape of the item differs from the other 3 things on this list, as the shape of the item cannot influence the functionality of the item. An example of this would be the Coca-Cola bottle, as the shape of the bottle does not influence how the Coca-Cola is made, or the ingredients in it, or how it tastes. It simply serves to distinguish itself from other soda. If the item were to if the shape of the item were to have an impact on the functionality of the item, that shape would need to be filed for a patent instead of a trademark. Something important to note about trademarks is that it does not give you ownership of the logo or the word or the brand itself. It simply excludes others from using that trademark on their own goods or services. The trademark allows you to tell your customers that this product did come from you and not from somebody else trying to replicate you. So here are 3 different types of logos that have been trademarked by companies. The first one is the Starbucks logo, which consists of a drawing that the company uses to brand themselves. The second one would be the McDonald's logo, which has the golden arches symbol that they use everywhere. And then you can also see that they've trademarked their slogan of "I'm loving it" as well. So that's another example of something that can be trademarked. And Coca-Cola has trademarked the word Coca-Cola as their brand name, and they use it in their logo as well to represent the company. So there are 2 different symbols that you have probably seen to represent trademark. There's the TM and the R inside of the circle. The TM is used to represent an unregistered trademark. This trademark doesn't have any sort of backing from a government agency and lacks a lot of protections that a trademark can provide. The R in the circle represents a registered trademark. In the United States, this can be registered at a national level and have national protection, as well as at a state level and have protections inside that state. Some of the benefits of having a registered trademark are the fact that the trademark owner can sue for damages and lost profits that they received because of somebody else using their trademark in a negative way. And they can also recover different attorneys' fees and costs while protecting their trademark against infringement. This becomes significant as it allows trademark owners to more readily go after people that abuse their trademark and infringe upon their rights. Unlike patents and copyrights, trademarks do not last for a set amount of time. Instead, a trademark will only expire after the owner stops using it. This allows companies to hold on to trademarks for as long as they are operating. 5 years after the trademark was initially registered, the company will have to go and make what is called a Section 8 declaration. In this, they will show proof and make a sworn statement that the trademark is still in use. 10 years after the initial registration, and every 10 years after that, the company will have to go back and continue to show proof that the trademark is being used until it is no longer being used, at which point the trademark will go back into the public domain.
Questions for the audience. What do you think is the most important innovation challenge that should be fixed and why? What are the issues caused by intellectual property? What's the difference between a patent and copyrights? How long does a patent last for? What are copyrights owners' rights?